This is case number 254847 SM, the people of the state of Michigan versus Becky Lee Harp. Ms. Harp, do you read and sign this advice of rights form today?
Yes.
The contact information on the back of that, is that accurate? Yes. Did you have the opportunity to meet with somebody from the defender's office today? Did you meet with Mr. Hartel? All right. I have a complaint that alleges that on or about November 14th, 2025 in the village of Meesick of Wexford County, it is alleged that you committed the offense of domestic violence. That is a misdemeanor punishable by up to 93 days in jail and or a fine of $500. Do you understand those charges and the potential penalties? You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one will be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney? And what is your current source of income?
I don't have an income. I'm being supported by family and friends currently.
Our court will make a referral to the public defender's office for the appointment of an attorney. We'll enter a not guilty plea on your behalf, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Historically, counsel, I show a 99 in MIP of alcohol, 09 a trespass, 11 a disorderly drunk, and 17 disorderly drunk. Those have all been automatically expunged from her record. The Praxis scores her at a risk level 2, so low risk. And a $500 bond has previously been posted. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. We would ask for bond to be continued. I believe that would be appropriate. As the court did know, she does not have a non-expunged record to speak of. And I do believe that she would obey any bond conditions the court wished to place on her. We do, of course, trust the court's discretion when it comes to no contact orders, things of that nature.
Thank you. Ms. Dahl, on behalf of the people.
Yes, Your Honor, I have serious concerns in this case. I would ask the court to consider a no contact with the alleged victim in this case, which is her daughter. I'm not sure if there's another parent or guardian available to take care of the child while this case is pending with a no contact provision. But it's alleged in this case that Ms. Harp used her elbow to hit her child in the face and left a red mark. And this is while it is alleged that she was drinking throughout the day and was intoxicated. So I'd also ask the court to do random alcohol testing and order that she not have any weapons or firearms.
Thank you. The court will continue the bond as previously set with the following conditions. Ms. Harp, you are to appear as ordered. Keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not have any contact with Phoenix Harp. No contact means no contact of any kind, not by phone, text, email, social media, anybody acting on your behalf. Do you understand that? I'm also going to order that you not purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior. Because alcohol is believed to be a factor in this case, I believe it's appropriate to order a no alcohol provision. And although they've been expunged, you have 3 prior convictions for alcohol issues, so I believe daily testing will be necessary in this case.
What if I'm unable to because I don't drive, I don't have a vehicle, and I have no friends or family?
The daily testing, you'll take a device with you and you'll blow into it. Community corrections will set the number of times that you blow into it, but there is a charge for that, just so you're aware. If you are found to be in violation of your bond conditions, you can be arrested without a warrant, brought back to jail, and have your bond revoked. You understand that? You can go out to the front window where you checked in, get your next court date. You'll probably have some paperwork to the defender's office if you haven't already done that, and then you'll need to go downstairs to community corrections and get signed up for testing.
Okay.
All right.
Thank you.
Thank you. A person at the Missaukee County Jail, please state your name.
Persephone Bowman.
I'm sorry.
Persephone Bowman.
This is case number 254351 SM, the people of the state of Michigan versus Persephone and Bowman. Ms. Bowman, you are here for a bench warrant for a fail to appear at arraignment on October 30th, 2025 on a charge of retail fraud second degree. That retail fraud second degree is alleged to have occurred September 16th, 2025 in Herring Township of Wexford County. And it is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000 or 3 times the value of the property taken. Do you understand those charges and the potential penalties?
Yes, sir.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. My question to you today is, do you wish to hire an attorney, represent yourself, or request the appointment of an attorney?
I'll just represent myself.
All right. Before I allow that, I have to be convinced that the waiver of an attorney is knowing and voluntary. So I'm going to read something to you. So bear with me while I do that. All right.
Okay.
This form says that I am the defendant in this case, and the judge has explained to me, and I understand that I have been accused of a crime, and I have read or have had read to me the charges against me and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I have the right to be represented by a lawyer at all stages of this process, and the court will appoint one for me at public expense if I cannot afford one. That I have the right to consult with a lawyer that I hire or that the court appoints. That I have the right to act as my own lawyer. That if I represent myself, I will be held at the same standards of law and procedure as a lawyer and will not get any special treatment from the court. The risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense in trial, and that the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection, procedure, or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. Ma'am, how many years of education do you have?
I graduated high school.
I have 12 years of education. I read and understand the English language, and I am mentally sound. Having gone through all that, do you still wish to represent yourself?
Yes.
All right. Today we have a couple of options for you. One is to plead not guilty. If you pled not guilty, the matter would be set for a pretrial, which would give you the opportunity to discuss the issues that brought you to court with the prosecutor and see if there's a way to resolve the case short of going to trial. You also have the right to plead guilty. If you pled guilty as charged, the 1 year misdemeanor would enter on your record, and we would probably be able to sentence today. So my question to you is, how do you plead to the charge of retail fraud second degree, guilty or not guilty?
Guilty.
In order to accept that plea, we have to go through a process. Will you please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Ma'am,
Yes.
may you put your hand down? So it's my understanding you'll be pleading guilty as charged retail fraud second degree, which is the 1 year misdemeanor. Back on September 16th of this year, were you on probation or parole?
No.
Were you on bond?
No.
Do you understand that you had the right to have a trial by jury and to have witnesses called for your defense at the trial, to cross-examine all witnesses called against you, the right to testify and remain silent, and if you remain silent, that silence could not be used against you. You also had the right to be presumed innocent and to be proven guilty beyond a reasonable doubt. By entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind. Do you understand that?
Yes.
Has anybody promised you anything in order to get you to plea today?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plea today?
Yes.
Ms. Dahl, are you aware of any promises, threats, or inducements not made part of the record?
No, Your Honor.
Then Ms. Bullman, to the allegation that on or about September 16th, 2025 in Herring Township, Wexford County, how do you plead to retail fraud second degree? Guilty or not guilty?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on September 16th, were you in the, looks like the Walmart store in Herring Township?
Yes.
And did you attempt to take some property or take some property that belonged to the store?
Yes.
Did you actually get out of the store with those items?
No.
Where were you stopped?
At the first exit doors.
So were you in kind of the vestibule area or were you still in the store?
I was, like, I would say probably 2 steps out of the, like, in between area.
So where the shopping carts are parked there?
Yeah.
And would you agree with me that the items taken had a value of at least $200, but less than $1,000?
Yes.
What is it that you took?
Camping stuff. And, fuel for food.
And was it your intent to leave the store without paying for those items?
Yes.
Ms. Dahl, do you believe the defendants provided the factual basis to accept the plea and the court rules have been complied with?
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Ms. Bullman, I find you guilty of retail fraud second degree. Are we able to sentence today?
Yes, Your Honor, none of the items, well, I'm sorry, all of the items were recovered, so there's no restitution in this case.
All right. Ms. Bullman, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
No, thank you.
What are you currently in Misaki for?
A bench warrant for a civil infraction for no insurance that I mixed up the dates on.
Have you been arraigned on that? Have you been arraigned on that yet?
No.
All right. Historically, in the defendant's past, I show in 15, there was an attempted operating without a license, in 18, 2 convictions for embezzlement. The defendant failed to appear in this matter on 2 separate occasions. So I believe placing the defendant on probation is not a good use of resources in this case, so it will be a straight jail sentence. There'll be 10 days jail with 1 day credit. With 1 day credit, there is a $75 crime victims rights fund fee, $50 state minimum fee, $150 fine, $150 court costs. I believe jail is appropriate given the fail to appears, the fact that this is retail fraud second, and that there are prior theft convictions in the defendant's past. Ms. Bullman, you do have, because I have sentenced you to a period of incarceration, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you in that regard, you have 14 days from today's date in which to request the appointment of an attorney to assist you with an appeal. Additionally, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. Do you understand that?
Yes.
Okay. When you are released from the jail over there, you're going to need to get a hold of the court here in Cadillac, the district court, and either make a payment or get set up on a payment plan. All right.
Okay.
All right. Thank you. Thank you, Misaki.
Thank you, Judge.
A person at the Wexford County Jail, please state your name for the record.
Joshua Adam Nason.
Mr. Nason, I'm Judge Wiggins in the 84th District Court here in Cadillac. You're here for a bench warrant for fail to appear at a financial review hearing. Is Sharon Road Southeast your current mailing address?
Yes, the letters that were mailed to me went to my address here in Cadillac with 414 East North, and then it got forwarded out to my parents' house, which now that's where I'm currently residing.
Okay.
But
And then is a phone number ending in 6408 still a good number for you?
yes, it is.
I show that you currently owe the court $858 with the last payment made in March. Are you able to make any payment on that today?
Currently, I have no way to make any money, like any payment towards that today. But, I have a vehicle I'm gonna sell and go pawn some tools as soon as if I'm able to get out of here.
All right, so Mr. Nason, what I'm going to do is I'm going to release you on a PR. Oh, okay. So on the financial review hearing, I'm going to release, yes, sir.
I was also gonna go talk to Mr. Thomas Holsinger, because he's a pretty understandable man, and see if we can come to a conclusion about the money that I owe him, or come to an agreement, even if I have to pick up dog poop. Like, I'm willing to do it. Like, I don't wanna come back here.
Well, so I'm going to release you on a personal recognizance bond for the financial review hearing. I'm gonna set that in 3 months. Now, that's different than the matter you have with Mr. Holsinger, and we'll get to that in a moment.
Okay,
So we'll reset the financial review hearing in 3 months. If you start making a payment on it, we'll cancel that, but if not, we'll get you back here and we'll see if maybe your financial situation hasn't changed and we get you on a payment plan, all right?
and is that for the 300 or whatever?
That's for the 858.
I got different paperwork than you.
Well, so the 300 there was a bond set for $300. I'm canceling that $300 bond and I'm going to allow you to get out of jail, all right?
Okay, thank you.
But you owe the court a total of $858.
Okay,
So then we'll switch over to Mr. Holsinger's case, which is case number 24483 SC. So are you Mr. Holsinger?
No, sir, I'm his father.
Okay. On that case, you're here for a fail to appear for a creditor's examination on September 25th. And looked like you owed $516 for that. What I'm going to do for that today is I am going to release you on a PR. And we'll reschedule that creditor's exam. Now, you're going to get that court date before you leave jail today. Make sure you make note of that. Do you have any questions for me?
no,
Okay. All right. Say your name.
Catherine Elizabeth Shattuck.
This is case number 254712 SD, the people of the state of Michigan versus Catherine Elizabeth Shattuck. Ms. Shattuck, you are here on a bench warrant for an alleged bond violation. It is alleged that you tested positive for alcohol on November 16th of 2025. You do have the right in this matter to have a contested hearing. If you wanted a contested hearing, the prosecution would have to put on evidence to convince the court that there was in fact a bond violation, or there is the option to plead to the violation, to plead guilty to the violation. You have Mr. Hartel, your office currently represents Ms. Shattuck, is that correct?
That is correct, Your Honor.
And how are we going to proceed today?
Your Honor, she's advised me she would wish to do an admissions today.
Is that true, Ms. Shattuck?
Yes, sir.
Ms. Dahl, any objection to that?
No, you're.
All right. Now, will you please raise your right hand? You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
I do.
Let me put your hand down. So it's my understanding, ma'am, according to Mr. Hartel and yourself, that you are going to plead guilty to having a positive test for alcohol on November 16th. Is that correct?
Yes, sir.
Has anybody promised you anything in order to get you to plead?
No,
Has anybody threatened you in any way?
no.
And is it your own free choice to plead?
Yes, sir.
Then to the allegation that you violated your bond condition by testing positive for alcohol on November 16th, 2025, how do you plead?
Guilty.
Is it true that the condition of your bond was that you were not to consume alcohol?
Yes, sir.
And is it also true that on or about the 16th of this month, you consumed alcohol?
Yes, sir.
You were tested by community corrections on, it looks like, both the SoberLink device and a urine test.
Yes.
And did both of those come back positive?
Yes.
Do counsel believe the defendants provided a factual basis to accept the plea?
Yes, Your Honor.
Yes, Your Honor.
Ms. Shattuck, I agree. I find you in violation of your bond. Any comment regarding bond moving forward, Mr. Hart?
Yes, Your Honor. I would ask the court to consider continuing her bond. I know that if I recall correctly, she posted a modest amount initially, and she has admitted to error in judgment. I realize that the court takes these things very seriously, and I've advised her that it would be a grace of the court if she was not required to post any additional monies. But if she did have to post any additional monies, we'd ask it to be around the same amount, relatively low. She is, of course, low income. That's one of the reasons why she is using the public defender's office. She's also aware that if the court did give her that grace and she had any further issues on bond, not only would the court almost certainly never be that kind twice, but the prosecutor would factor that into any plea negotiations, and they would factor that in any sentencing, whether or not it's reasonable to consider her supervisable if we were in a situation where that was applicable in the future. I do believe she's doing this very seriously, and I just ask the court to factor that in. Thank you.
Ms. Dahl?
I have serious concerns that right after she was arrested and then released for an OWI with a high VAC, she is continuing to drink while under the supervision of the court. Although her breath tests on SoberLink were not as high, they were close to the legal limit of operating the vehicle. I have serious concerns about her drinking and driving again while she's on bond. With the conditions already said to ensure that she will not drink, and then to violate those conditions, I would ask the court to impose an additional money bond. And I would ask the court to also add conditions of her seeking treatment, whether that be AA or equivalent group meetings every week, to make sure that she focuses on sobriety and that she is not a danger to the public. Thank you, Your Honor.
Thank you. Bond in this matter was previously set at $250 with the conditions that the defendant not consume alcohol or controlled substances, including recreational marijuana, subject to the daily testing for alcohol, random testing for controlled substances. In the defendant's past, in 22, there was a disorderly drunk. In 21, there was a 4A case. In 17, there was operating while intoxicated. At least at the time of the arraignment, it was reported that the defendant was 0.223 at the PBT at the time of her arrest. The court is faced with somebody who is on her second drunk driving, blew very high at the time of her arrest, and according to the SoberLink report, at 6 a.m. was blowing a 0.072. The court is going to remand the defendant to the custody of the Wexford County Jail and forfeit bond.